In property law, a mortgagee with a purchase money mortgage, that is, a mortgage given as security for part of the property's purchase price, has priority over all other interests, regardless of when those interests were recorded. But what if the seller and a third party both receive purchase money mortgages from the buyer at the same time? A federal bankruptcy court in New York considered this question in the case of In re Smith. Scott Smith purchased a home with loan money that he received from two sources. First, in exchange for a $68,000 loan from PCFS, Smith executed a note secured by a purchase money mortgage, or PMM, on the property. Second, in exchange for a $16,217 loan from sellers Robert and Marty Jane Zach, Smith executed a second note secured by a PMM on the property. PCFS recorded its mortgage on the land records on January 12, 1999. 10 days later, the Zachs recorded their mortgage on the land records. A few years later, Smith filed for bankruptcy. At the time, Smith owed PCFS roughly $70,000 and the Zachs approximately $15,000 on the notes. But the property's fair market value at the time was only $65,606. Subsequently, Smith filed a motion in bankruptcy court to avoid the Zach's PMM, arguing that PCFS's prior recorded lien exceeded Smith's equity in the home. As a result, Smith claimed that Zach's mortgage was unsecured and avoidable. The Zachs counterclaimed that their PCM was a vendor's lien and had priority over all other liens. The court considered the motion.